Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast 101, which sounds like a title for a very basic podcast series if you ask me. Anyway, thank you very much for the nice comments which I received on reaching our 100th episode, that milestone. The comments were much appreciated, and the bad news is if there's any danger of me stopping when I got to episode number 100, the nice comments have certainly spurred me on. Anyway, in this podcast episode, we've got three cases, all from the AT. First deals with what happens when an employee appeals against a decision to dismiss him. The appeal is upheld, but the employee is dissatisfied with the outcome. Secondly, what's the difference between the common law without prejudice rule on exclusion of evidence and excluding it by reason of section 111A of the Employment Rights Act? And finally, can a claimant claim damages if he's applied for a job which he had no intention of taking up? As usual, don't forget you can access the podcast via iTunes, it's on the Mayor Brown Internet, it's YouTube, and the Twitter feed Nicholas Robertson at Nicholas ROBER11, which is also, of course, where we post out links to all of the cases discussed. So, first up, Folkestone Nursing Home Limited and Patel. This is an EAT case dealing with the issue of the impact on an employee appealing against a decision to dismiss. The decision to dismiss was on the grounds of gross misconduct. I think it's an interesting case, but it also flags up there's an outstanding issue in this area which is still to be decided. Let me explain. Mr. Patel worked as a healthcare assistant for Folkestone Nursing Homes. He was dismissed for gross misconduct, and there were two charges. The first, that he was sleeping on duty. That was the allegation. The second allegation was that he was falsifying residents' records. When he was dismissed, he appealed, and the appeal letter rescinded the decision to dismiss. So the decision-maker acknowledged that Mr. Patel was on an unpaid break when he was asleep, and therefore he was entitled to do what he wanted in that period. On that basis, the appeal letter continued, he would be contacted to arrange his return to work. However, the claimant did not return to work. He asserted that the appeal decision letter was incomplete. It did not adequately address the grounds of his appeal. It didn't make any mention of the allegations about falsified records. Moreover, even for the charge that was dropped against him, Mr. Patel said the reasoning was inadequate, and he was due full and proper reasoning. He never returned to work. He claimed unfair dismissal. The Employment Tribunal found that he had been dismissed, despite the fact that his appeal had been successful. There were two separate reasons. First, the appeal procedure itself, referenced in the contract, did not state exactly what would happen if the appeal succeeded. This aspect of the Tribunal's reasoning was based on the earlier case of Roberts and West Coast Trains Limited, where there had been a contractual appeal process and it specified the outcome of an appeal could cover a variety of outcomes. Here, although the contract of employment included the disciplinary procedure, there was nothing specifically stated about what would happen in the event of a successful appeal. Therefore, the Employment Tribunal felt this was different to Roberts. Secondly, the Employment Tribunal said the failure to deal with what was admitted to be the more serious of the two allegations in the appeal letter, despite the fact that the claimant had appealed against that finding as well, meant that the decision had not been revoked. The Tribunal characterised the appeal letter as an offer for the claimant to return to work, which the claimant did not take up. The claimant won in front of the Tribunal, although there were findings for contributory fault on his part. Everyone involved then appealed to the AT, and so the case went there. The AT focused on the issue of dismissal and whether or not there had been a dismissal in the first place. This, of course, was a jurisdictional issue for the Tribunal and for Mr. Patel's claim, and so it was the first hurdle which the claimant had to get over. However, unfortunately for the claimant, the EAT disagreed with the Employment Tribunal. There had been no dismissal. The starting point was, as the Tribunal had considered, the case of Roberts and West Coast Trains. The EAT acknowledged that in that case the disciplinary process was contractual, and it was stated the employer could choose to impose a different sanction in place of the earlier decision to dismiss. In the circumstances, this included substituting a lesser penalty for dismissal, and a contract, in that case, it was said, was in effect automatically revived when Mr. Roberts' appeal was successful. However, crucially, in a second case, Salmon and Castlebeck Care, the AT had said it must be implicit in any system of appeal that the appeal panel has the right to vary or revoke the decision made in the first instance. in my terms, by electing to appeal, the employee was offering the employer the chance to undo what the employee was saying was an earlier mistaken decision to dismiss. Therefore, here, in the Patel case, the EAT said that the disciplinary procedure, which, as I say, was contractual, implicitly allowed the employer the right to substitute the decision to dismiss for a lesser decision. To the extent that the fact that the appeal panel's reasoning was inadequate and failed to deal with significant aspects of the employee's appeal, that did not prevent the decision being revoked. As such, the claimant's case fell at the first hurdle. He had not been expressly dismissed by the employer. Well, I think this case is helpful. It reiterates a useful point. It does, of course, place claimants in a bit of a cleft stick. If they appeal, then they're granting the employer the right to undo what might be an erroneous decision with liability attached to it. And clearly, here, the employee's reaction to being effectively told his appeal was successful was a rather odd one. But it may be understandable if the employee felt the employer had been treating him very unfairly and was still not acknowledging that unfairness. However, there are two critical points I wanted to make. First, the case proceeded on the basis that there was either an express dismissal by the employer or there was no dismissal. It was not argued by the employee that the inadequacies in the appeal letter amounted to a constructive dismissal. I would certainly have thought that argument had some legs to it, if the facts were supportive. And obviously we don't know, because the EAT did not look at whether the employer's response in this case was reasonable or unreasonable, or whether the employee should have asked for clarification rather than refusing to return to that work, to work at that point, so on. We simply don't know from the case report. But an employer who is faced with a similar claim in the future might find that the constructive dismissal claim is a rather more difficult one to respond to. Secondly, all these cases, Roberts and Salmon and so on, have proceeded on the basis that there was a contractual disciplinary procedure. What is different about this case and the Salmon case was that there was no contractual statement about what the outcomes of an appeal could be. The EAT recorded that it was addressed by the employee's representative in this case on what would happen if the disciplinary procedure was not contractual. And of course, for most employers, the disciplinary procedure itself is not a contractual one. So where does this leave things? Well, I think a lot would depend on the wording of the contract and how the disciplinary process is set out. I suppose one potential outcome would be that there's a contractual right to appeal, but the process followed is non-contractual. But if you had something where the entire disciplinary procedure is not contractual, including the ability to appeal, I can see that may be much closer to the line. Would a dismissal in those circumstances be automatically revoked? However, I would have thought the more logical outcome would be to say that, by appealing, the employee implicitly is granting the right to the employer to revoke the decision which is being appealed. Otherwise, it would be an invidious position for an employer, since a successful appeal, if it didn't automatically revoke the decision to dismiss, could always be held against the employer. So, that's the case of Folkestone and Patel. Next up, Faithorn, Farrell Timms plc and Bailey. This is an EAT case dealing with the admissibility of correspondence between the claimant and her employer, which was said either to be on a without prejudice basis or was covered by Section 111A of the Employment Rights Act. And it's an important case because it highlights the differences between the statutorily inadmissible correspondence under Section 111A and the common law without prejudice rules. It's probably easiest to start by explaining the facts briefly, although noting the case is still continuing and so there's been no final determination of the underlying points in issue. Claimant worked as an office secretary in a surveyor's firm. She worked on a part-time basis, but apparently problems arose which led to her departure at the end of February 2015. It was accepted by the parties that, by 7th January 2015, the parties were in dispute. So fundamentally it was possible for correspondence passing between the parties to be on a without prejudice basis. The claimant's lawyers wrote on more than one occasion, initially on a without prejudice basis, seeking to resolve matters. The respondent's letters of response don't seem to have been marked without prejudice. The claimant then relied on the content of the respondent's letters in her internal grievance, and the respondent didn't object to this. The claimant then referred to matters in her tribunal claim form, arguing there was an underlying strategy to bully her out of her role to avoid a financial settlement. Once again, the respondents did not object to the use of the allegedly without prejudice material, and indeed they too referred to it in their pleadings and putting forward their side of matters. The claimant was claiming unfair dismissal and unlawful discrimination. After the proceedings had started, someone on the employer's side took the point that some of the correspondence was without prejudice and or covered by Section 111A. The issue for the Employment Tribunal and then the EAT was whether the allegedly without prejudice material and the fact that there was without prejudice correspondence could be referred to in either or both the unfair dismissal claim or the discrimination claim. The Employment Tribunal allowed the documents in and said that neither the without prejudice rule nor section 111A prevented the material being used. Respondent appealed, and the EAT had to look at the rules governing the admissibility of evidence under the without prejudice rule and section 111A. And it's the differences between the issues that arise that make this case an important one. Starting with the common law without prejudice rules, the without prejudice shield, of course, is there to allow parties to make a genuine effort to resolve a dispute, to negotiate frankly without the risk that anything said in negotiations will be used against them in subsequent legal proceedings. It's not uncommon to find that one or other side makes references to without prejudice correspondence in open correspondence, particularly before external lawyers are involved. However, the courts are willing to be, in my term, sensible about this. For example, Brunel University and Versailles, the Court of Appeal accepted that in an internal grievance hearing, references by both parties to without prejudice correspondence did not necessarily amount to a waiver of the without prejudice label on that correspondence. Here, however, the Employment Tribunal had found that the correspondence between the parties mostly consisted of correspondence about the case and was not evidence of a negotiation seeking to resolve a dispute. The EAT felt this was an assessment the Employment Tribunal had been entitled to come to. However, the claimant had also cross-appealed because the Employment Tribunal had not addressed her argument that the respondent had, in any event, waived any without prejudice protection by referring to matters in their pleadings, and the EAT accepted this was the case. The respondent had expressly relied on material which it now said should not be admitted. Since the employer had unequivocally waived the without prejudice label, the shield, by its use of materials in the pleadings, the common law without prejudice rule would not prevent the material being used. However, that left the arguments under section 111A. Briefly, that section says that evidence of pre-termination negotiations is inadmissible in unfair dismissal proceedings. There are some exceptions. If the claim is for an automatically unfair dismissal, discrimination for example, then section 111A doesn't apply. Similarly, if the tribunal considers that anything said or done is improper or connected with improper behaviour, then the tribunal has a discretion to admit as much of the material as it thinks is just. Here, the issues for the EAT were, firstly, was this material covered by section 111A? And secondly, could the fact of the without prejudice negotiations be admitted in the unfair dismissal claim, even if the material could not be? And thirdly, could material covered by section 111A be used if both parties agreed it could be used, i.e., in this case, the respondent had waived its objections by putting the material in its pleadings? The short answer is that the EAT said that section 111A was different to the common law without prejudice rules. Looking at the wording of the statute, the EAT took the view that the fact that there were without prejudice discussions was also excluded under section 111A, and this was not material which could be used by the agreement of the parties. In other words, the concept of waiver, inadvertent or otherwise, simply didn't arise. Moreover, discussions within the employer about an exit strategy for the claim would also potentially be shielded. In other words, material was not going to be admitted by the back door simply because there was preparatory correspondence showing the contents of the settlement offer within the employer before the offer was then pitched to the claimant. Overall, I think this is a helpful case for employers. I must admit we were pretty sceptical about the benefits of the rules under section 111A, and I don't think we've tended to rely on them when we've been looking to negotiate settlements. It's obviously quite artificial to expect an employment tribunal, where there's both an unfair dismissal and a discrimination claim, to somehow put out of its mind what may have been going on behind the scenes, and which it is legitimately aware of when considering the discrimination claim. However, I think this case may offer an opportunity for an employer to claw back a situation where material may have been inadvertently disclosed, or email traffic within the employer about without prejudice discussions may itself not be without prejudice. I think it follows from this that employers' advisors need to be familiar with this case because it may be very helpful in the future, particularly if they're taking over a case where the parties have been in correspondence client to client beforehand. So, next, third and final case is Kratzer and Allgemeine Versicherung, and my apologies for butchering that name. This is a decision from the ECJ under the Equal Treatment Directive. The point it makes is quite a short one. I just wanted to mention the case partly because it's an ECJ decision, but also to caution against over-reliance in this case. Background, the sort of summary background facts that we have from the decision, is that the claimant applied for employment with Allgemeine. It appears that there was some sort of mix-up because he was automatically rejected, but then subsequently invited for an interview. He refused to go for the interview until compensation had been sorted out, and when it was not sorted out, he brought a claim. Case went up through the German courts, and then there was a referral to the ECJ to establish whether or not the Equal Treatment Directive covered an individual who was not interested in taking the job, but was making a job application for the purpose of bringing a claim for compensation. From the case report I've seen, it's not entirely clear why the German courts took the view this wasn't a genuine job application, but that was the assumption that was being made by the ECJ. The ECJ were clear the purpose of the directive was to protect people seeking employment. You are not seeking employment if you're merely making a job application because you're seeking compensation. Similarly, an individual would not be a victim of discrimination if they were not genuinely seeking a job. It would be open to the National Court, the ECJ said, to find against a claimant in Mr. Kratzer's position if fundamentally the claimant was not interested in taking up the post but looking to obtain compensation artificially. And in the UK, we've had a similar case, Keane and Investigo and others, which took the same approach to compensation. So why mention the case? Well, a number of years ago, there were serial claimants around who would apply for jobs in industries where it's felt that there was historic and inbuilt discrimination throughout the industry. And there were instances of claimants seeking compensation on multiple occasions from different employers in one sector. We've seen less of that in my experience. It may well be that tribunal fees have put people off, and equally employers generally may have tightened up procedures for job applicants. However, I would in any event caution an employer about relying on this particular case unless there was clear evidence that the individual had no interest in applying for the job, and I think that would be very difficult to come by. It could backfire spectacularly if you ran this argument and a tribunal felt sympathy with the claimant rather than the employer. To that extent, it's also clear that a claimant is not disqualified from compensation and pain and suffering awards merely because he or she has been discriminated against in a number of occasions in the past. So the mere fact that you identify that your claimant is a serial litigant does not amount to anything like cast iron evidence that he's not interested in taking the job. So that's the Kratzer case. So there we are, end of the podcast episode 101. Thank you very much for listening. Please do take a moment to listen to the special podcast that we did. I wanted to explain the background to the podcast series and my thoughts. If you're interested in doing a podcast series of your own, any lessons to be learned, happy to offer them. As always, no employees were harmed in the making of this podcast. And until episode number 102, stay safe and talk to you then. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.